Standing. The issue here is whether there is either individual or associational standing. In order to have standing, one must have suffered a concrete and particularized injury. In fact, there must be causation between the defendant's conduct and the plaintiff's injury and redressability by a favorable decision of the art. 3. Court must exist. In addition, we should note that the association bringing the lawsuit here is exactly that, an association, and not an individual. There are additional rules in order to find associational standing. First, the individual members who make up the organization must have standing. Second, the lawsuit at issue must accord with the organization's purposes. Third, the association must be able to sue in its own right, without requiring the active participation of its individual members. Ripeness. In order to be ripe, a lawsuit must be capable of actually being determined. Issues of ripeness arise with respect to proposed legislation, ordinances that have not yet been enacted, laws that have not yet been violated, and so on. In short, the injury is essentially to come, and the plaintiff is seeking a declaration that the ordinance, or otherwise, is invalid before harm can occur. Mootness. Federal courts may only decide live controversies. 2 exceptions to the mootness doctrine. 1 exists where the problem in the lawsuit is capable of repetition, yet evading review. Voluntary cessation mootness exception. Where the conduct complained of by defendant pauses, or is halted, such that the live controversy disappeared as a result of defendant's own free will, the case cannot be said to have been resolved. Rather, it is wholly possible that upon dismissal of the case the defendant will begin to once again engage in the conduct complained of. As such, voluntary cessation is an exception to the mootness doctrine. Sovereign immunity. Municipalities are not entitled to state sovereign immunity under the 11th Amendment. Government action. The First Amendment applies only to government action. The First Amendment is couched on Congress not making any law that violates a person's rights. It is extended to state and local government through the 14th Amendment Due Process Clause. Free exercise. A person has the absolute right to their religious beliefs, but religious conduct may be limited in some circumstances. The government may pass laws that limit religious conduct, but they are more likely to be upheld where the laws only incidentally limit religious conduct. Where a law is facially neutral, such that the prohibited conduct applies equally to religious and secular conduct, absent a showing or discriminatory motive, the law must merely meet rational basis scrutiny. This requires the proponent to prove that the law is not rationally related to a legitimate government interest. On the other hand, where a law is facially discriminatory, such that it is aimed at tailoring religious conduct, it is subject to strict scrutiny. This requires the government to show that the law is narrowly tailored to meet a compelling government interest. Establishment Clause. The First Amendment also prohibits the government from favoring one religion over others or favoring religion over non-religion. The government must show 1. The law has a secular purpose. 2. Its primary aim is not to advance or inhibit religion, and 3. The law does not excessively entangle government with religion. Government action. First, to bring a claim under the U.S. Constitution and the Establishment Clause, there must be a government action. Establishment Clause. Under the Establishment Clause, the government cannot take action or promulgate a rule that has the effect of establishing or inhibiting religion. In order to determine whether government action violates the Establishment Clause, the court will apply the Lemon Test. The Lemon Test has 3 factors. To meet these 3 factors, the government must show that I. The action has a secular purpose, 2. That the action's primary effect is not to advance or inhibit religion, and 3. There is not excessive entanglement between the government action and religion. Free exercise of religion clause. Under the First Amendment of the Constitution, every person has the right to the free exercise of his or her religion. When a government action or regulation is based on or discriminates against religion, it must pass strict scrutiny. Strict scrutiny requires that the government action is necessary to achieve a compelling government interest. Whether a religion is protected under the Constitution is not based on whether the particular religion is well known or well established. Rather, the court will look at whether the individual has a sincerely held religious belief. Put another way, the question is whether the individual's belief, and whether that belief has a similar role in the individual's life as a typical religion would. Equal protection. Citizens are entitled to equal protection of the laws of the United States. This applies to the federal government under the Fifth Amendment, and is applicable to the states under the 14th Amendment. Under the Equal Protection Clause, an action or law that discriminates against a suspect class must pass strict scrutiny. Actions based on religion, as mentioned, must pass strict scrutiny. Thus, because the government action is not equal, and it is based on religion, it must pass strict scrutiny. Commerce Clause. Under the Commerce Clause in the U.S. Constitution, Congress has the authority to regulate interstate commerce. This includes I. The channels of interstate commerce, roads, railways, waterways, 2. The instrumentalities of interstate commerce, trucks, boats, airplanes, the internet, and 3. Economic activities that, when aggregated, have a substantial effect on interstate commerce. Dormant Commerce Clause. However, this authority is not absolute. States are allowed to regulate commerce if such regulation is not preempted by federal law, and so long as the state regulation does not discriminate against out-of-staters. If the state regulation discriminates on its face against out-of-staters, it violates the DCC unless the regulation is necessary for a compelling state interest, strict scrutiny. If the regulation does not discriminate against out-of-staters, it usually will be upheld so long as it does not unduly burden interstate commerce. Citizens, including individuals and corporations, as well as aliens, can sue on a cause of action arising under the DCC. Market participant exception to DCC. Whether State X is a market participant. Congress has provided 2 exceptions to the DCC, I. Consent by Congress, and 2. When the state acts as a market participant. Privileges and Immunities Clause of Article 4. The PNI Clause guarantees that citizens of each state shall be given the privileges and immunities of citizens of all states. A state law which discriminates against out-of-staters as to a fundamental right or civil liberties, including the ability to earn a livelihood, violates PNI Clause unless a substantial justification exists. Equal protection. The Equal Protection Clause under the 14th Amendment to the U.S. Constitution applies when the government is making a distinction between similarly situated people. If the classification is based on race or national origin, then the state must meet strict scrutiny. If the classification is based on gender, then intermediate scrutiny will be used. Any other classification will only need to meet a rational basis test. As the challenger, Peter will have the burden to prove the act does not meet the rational basis test. Contracts Clause. Under the Contracts Clause of the U.S. Constitution, a state may not impair rights under pre-existing contracts. If the interference is with a private contract, intermediate scrutiny applies. If the interference is with a government contract, strict scrutiny applies. Due process. The Due Process Clause of the Fifth Amendment applies to the federal government, and applies to the states through the 14th Amendment. Under the DP Clause, states must not act unreasonably or arbitrarily. The government cannot deprive individuals of certain rights without a counterbalancing justification for doing so. Individuals and corporations can sue under the DP Clause. Due Process Clause. The Due Process Clause of the 14th Amendment prohibits the states from depriving any person of life, liberty, or property without due process of law. Due process generally requires a fair procedure, usually notice and a hearing. Procedural due process. Under procedural due process analysis, the first inquiry is whether the plaintiff had a constitutionally protected liberty or property interest. If the plaintiff has a protected interest, the court will then balance the interest against the state's interests under Matthews. The court will also look to the risk of erroneous deprivation, and whether additional procedural safeguards would reduce such risk and burden on government's administrative efficiency. Traditionally, the Supreme Court differentiated between rights and privileges, and provided that only rights are protected under the Due Process Clause. The court since Goldberg, however, has held that a property interest is protected by the Due Process Clause if the plaintiff has a legitimate claim of entitlement. First Amendment, free speech teacher. Some speech is not protected under the First Amendment. Generally, the speech of a public employee made in the course of their employment can be regulated by the government employer. Employees' speech outside the scope of their work and regarding public issues, however, is protected by the First Amendment. Content-based regulations of speech must meet strict scrutiny. The restriction must be necessary to achieve a compelling government purpose. Content-neutral restrictions must meet intermediate scrutiny. They must be substantially related to and narrowly tailored to achieve an important government purpose. Procedural due process. If the court recognizes P's liberty interest, it must apply the Matthew balancing test to determine whether she should have been entitled to any additional procedures beyond her pre-termination notice. The court will balance 1. The private interest affected by the government action, 2. The government's interest including administrative and fiscal burdens, and 3. The risk of erroneous deprivate and the value of additional procedural safeguards. Standing. The plaintiff must have a concrete stake in the outcome of the litigation. The court has interpreted Article 3's conferral of the judicial power over cases and controversies to require the plaintiff to show I. That he has suffered an injury in fact, and 2. That the defendant's conduct was the cause of that injury such that a favorable court decision will remedy the injury, causation, and redressability. Injury in fact. First, the requirement that the plaintiff prove an injury in fact is generally satisfied if the plaintiff shows that they suffered an injury that was actionable at common law, such as pecuniary loss. However, the court has also recognized an injury in fact where the plaintiff's constitutional or statutory rights have been violated. Environmental, aesthetic, and stigmatic injuries are also judicially cognizable. However, when a plaintiff is seeking injunctive relief, he must show that there is a concrete, imminent threat of future injury that is neither conjectural nor speculative. 11th Amendment, sovereign immunity. The state and the AG also seek dismissal of the suit based on the 11th Amendment, which provides that a state is immune from suit in federal court. The 11th Amendment is similar, if not identical, to the doctrine of state sovereign immunity, which also applies to suits against states in state court. Alden v. Maine. A state may waive sovereign immunity under certain conditions, and Congress can override state sovereign immunity by statute using its enforcement powers under Section 5 of the 14th Amendment. In addition, state officers may be sued in their official capacities to enjoin the enforcement of a state law under Ex Parte Young. A state officer may also be sued in his or her individual capacity for retroactive damages, and may be indemnified by the state. Zoning powers. The Supreme Court has historically granted great deference to municipalities engaged in creating zoning ordinances. See Euclid v. Ambler Realty. Generally, local government has the police power to enact zoning ordinances so long as they are reasonably related to a legitimate government purpose, namely, that they relate to protecting the general welfare, safety, or health of the community. However, the facts indicate that the ordinance only applies to a single block. This raises the specter of spot zoning, which may be impermissible if used to single out landowners, or make a handful of landowners bear a disproportionate burden that the public at large should have to bear. In contesting zoning that appears to unlawfully inhibit a landowner's use of his property, a landowner may bring a takings claim challenging the constitutionality of the zoning ordinance on its face, or as applied. As demonstrated in Euclid, a facial challenge is bound to fail. Zoning has been upheld for decades. But an as-applied challenge can be viable, and is discussed below. Takings. Under the Fifth Amendment, and applied to the states via the 14th Amendment, the government may not take private property without just compensation. Typically, a government taking is through eminent domain, where the government must show a valid public purpose for the taking and compensate the landowner for the land the government takes for the public purpose. Physical takings. Any government statute that incurs a physical occupation of a landowner's land or real property, including airspace, must be compensated. Loretto teleprompter. Regulatory takings. Courts have held that an ordinance that is so burdensome, or that unduly burdens a single landowner in order to benefit the public at large, may be a regulatory taking and must be compensated. Under Lucas, a regulation that incurs a total economic wipeout, meaning that it deprives a landowner of any economically beneficial use of his land, is a regulatory taking and must be compensated. The one exception to the total wipeout rule is if the ordinance is based on pre-existing common law in the state, Lucas. Penn Central Multi-Factor Balancing Test. Penn Central Multi-Factor Balancing Test, in which the government determines if an ordinance incurs a taking based upon the government interest to be advanced, the nature of the government regulation, and the degree of interference with the landowner's investment-back expectations. Variances. Lastly, landowners may also seek relief through variances and amortizations if they do not wish to bring a constitutional claim under Penn Central. A variance can be area or use. An area variance allows a non-conforming use to vary by the area used. A use variance allows a non-conforming use in an area that is not zoned for that purpose. Use variances are typically harder to secure, and the landowner must show an undue burden if the use variance is not granted. Amortization. An amortization allows a non-conforming use to persist until ownership of the property changes, and prohibits the owner from expanding or changing his permitted non-conforming use. Amortization works to mitigate the impact of a sudden zoning change, which could deprive the landowner of economic use of their property, and also reduce the likelihood of a takings lawsuit. Government action. Government action occurs when the government acts, when a private entity takes on a public function, or when the government is entangled, encourages, participates in, or enables in private conduct. Content-based restrictions. All content-based restrictions on speech conducted in a public or designated public forum are subject to strict scrutiny. Under the strict scrutiny standard, the government has the burden to show that a law is narrowly tailored, using the least restrictive means to reach a compelling governmental interest. Content-based restrictions on speech arise when the government regulates either subject matter-based speech or viewpoint-based speech. Content-neutral speech conducted in a public or designated public forum must further an important government interest, be narrowly tailored, leave alternatives for speech open, but need not be the least restrictive means available. Prior restraint. Prior restraints are subject to strict scrutiny because they put a barrier on speech before the speech can occur. One such type of prior restraint is a permit that permits speech. To be valid, a permit must further an important government interest, involve little to no discretion by the person or group issuing the permit, there must be clear criteria to obtain the permit, and there must be a procedure in place for timely resolution of the permit and/or an immediate appeal of a decision. Overbreadth. A government regulation of speech is overbroad and invalid where it regulates more speech than intended. Vagueness. A regulation of speech is vague and invalid where it is unclear what speech is prohibited and what speech is not prohibited. First Amendment right to freedom of religious expression. The general rule regarding freedom of expression is that neutral laws of general applicability that have the effect of infringing on freedom of expression do not violate the right to freedom of expression. However, when a law is not neutral, strict scrutiny applies, requiring the government to show that the law is necessary to further a compelling government interest and that the law is the least restrictive means possible. Establishment Clause. The government may not establish a particular religion under the Establishment Clause of the First Amendment. To determine whether government action violates the Establishment Clause, the court applies what is called the Lemon Test, which analyzes the government action under three prongs: 1. Whether the government action has a secular purpose; 2. Whether the action has the effect of promoting or inhibiting a particular religion or religion in general; and 3. Whether the action results in excessive entanglement between the government and religion. 13th Amendment Involuntary Servitude Clause. The 13th Amendment is one of the broadest amendments to the Constitution, applying not only to government actions, but also private actors. A regulation is unconstitutional under the 13th Amendment if it compels one person to work for another, even if compensation is paid. 14th Amendment's Due Process Clause. There are two prongs to the Due Process Clause of the 14th Amendment. The procedural due process prong strikes down any law that deprives a citizen of a fundamental right without proper procedural safeguards. On the other hand, the substantive due process prong strikes down any law that denies a citizen a fundamental right. Procedural due process, deprivation of a fundamental right without a hearing. Procedural due process requires the government to provide the proper procedural safeguards to prevent the erroneous deprivation of a fundamental right. Typically, procedural safeguards include notice, a hearing, and/or the right to have an attorney. When evaluating whether a particular law requires these procedural safeguards, courts look at the person's interest in the right, the court's interest in efficiency, fairness, and accuracy. Substantive due process, right of liberty. Because this statute denies Pete his fundamental right of liberty, it must meet strict scrutiny. Strict scrutiny requires State X to prove that the statute is necessary to achieve a compelling government interest. Courts use the least restrictive alternative test. If there is a lesser restrictive alternative to the statute, then the court will strike the statute down. Substantive due process, right of privacy, parental rights. The Supreme Court has held that the penumbra of the Bill of Rights, incorporated and applied to the states through the 14th Amendment, has created a fundamental right to privacy. Moreover, the Supreme Court has found that included in the fundamental right of privacy is the right of parents to control the upbringing of their children. 14th Amendment's Equal Protection Clause. A regulation that has a classification on its face is subject to constitutional attack under the Equal Protection Clause of the 14th Amendment. The Equal Protection Clause provides that no state shall enact a law favoring one citizen over another. Age-based classification. The Supreme Court has ruled that age-based classifications are non-suspect classifications that are subject to the rational basis test. Under the rational basis test, the law will be upheld unless Pete or his parents can prove that the law is not rationally related to a legitimate government purpose. Gender-based classification. While age-based classifications are subject to the rational basis test, gender-based classifications required heightened scrutiny. In order to withstand a constitutional challenge, a gender-based law must be substantially related to an important government interest. Unlike the rational basis test, here the government bears the burden of proving that the law is constitutional. Free speech. Under the First Amendment as applied to the states via the 14th A, all persons have the right to free speech. While this right is not absolute, there are only certain instances when the government may infringe upon this right. Strict scrutiny. Normally, when a government actor limits or regulates speech based on its content, it will have to survive strict scrutiny analysis. Under this, a law will only be upheld if it is necessary to achieve a compelling government interest. Time, place, and manner restrictions. One way a government may validly regulate speech is by controlling the time, place, and manner of the speech. These regulations are put under less scrutiny because they are not limiting what the people can say, but rather how and where they can say it. Public forum. A public forum is a place that is traditionally open to the public and allows somewhat unrestricted speech. These include parks, sidewalks, open fields. The bus station bulletin boards are likely not considered a public forum. Limited public forum. Limited public forums are not traditionally open to public speech, but the government opens them up to the public. Therefore, they receive the treatment of a public forum while open. While open to public speech, a limited public forum may only regulate the time, place, and manner of speech if 1. Content neutral. 2. Alternative channels of communication are available, and 3. Regulations are narrowly tailored to achieve a significant government interest. Non-public forum. Gov can regulate speech in non-public forums, as long as it is reasonable and viewpoint neutral. Commercial speech. That speech can be regulated if not false/misleading, directly advances substantial gov interest, and narrowly tailored into it.